Passed in 1965, the Voting Rights Act put an end to discriminatory voting practices. Now, just after President Obama's re-election, the Supreme Court has announced that it will hear arguments in Shelby County versus Holder. At issue in the case is something called preclearance, which means federal approval for a state to change its voting laws.
Preclearance is the requirement that all or parts of 16 states have to go through any time they want to change anything at all, no matter how minor, that affects elections.
16 states are currently under Section 5's preclearance requirement, the majority being southern states. Now, since its inception, the requirement has been extended numerous times, the last being in 2006. But if the requirement is struck down, what will this mean for Georgia?
The real consequence will be is actually some money saving, because the state will no longer have to worry about sending up all these changes to the federal government and then hiring lawyers to make sure they can follow the cases and if there's challenges, then fight them in court.
Yeah, that'd be some money saved.
But how will the court rule? Dr. Owens says the departure of moderate Sandra Day O'Connor from the court may lead to the section being struck down.
And if the court is more conservative than she is, then I'm afraid you probably will end up maybe with that 5-4 split.
For Grady News Source, I'm Ryan Williams.